The Supreme Court has held that state legislature may make law to give preferential reservations to subcastes within categories. In doing so, the court has diverged from another constitution bench judgment that held the contrary. The decision was rendered by a constitution bench of Justices Arun, Mishra, Indira Banerjee, Vineet Saran, Shah and Krishna Murari. The questions for considerations before the bench was whether the Supreme Court 2004 judgment in the case of the Chinnaiah versus the State of the Andhra Pradesh needed to be revisited. In that judgment, the apex court had held it to be unconstitutional for the state legislature to provide a further sub-categorizations of scheduled caste and scheduled tribes. While pronouncing the judgment, Justice Mishra said that the bench of the review that once the state has the power to give reservation, it can also make sub-classifications to extend benefit to those subcastes not receiving the benefit. The issue has now been placed before the Chief Justice for forming a larger bench to definitely decide the questions. The questions was posed before the Supreme Court in a batch of appeals against the decisions of the Punjab and Haryana High Court, which struck down Section 4(5) of the Punjab Scheduled Caste and Backward Classes Reservation in Services of Act of 2006 as being unconstitutional. This provision had carved out a preferential favor of the Balmiki and the Mazhabi Sikh from 50% quota reserved for the SC communities in case of the direct recruitments. This provision was struck down by the High Court based on the EV Chinnaiah, which held that all the scheduled caste enlisted under Article 341 of the Constitution of India form one homogeneous group, and this group cannot be served into a subdivisions or sub-classifications. However, a three-judge bench of the Supreme Court in 2014 preferred the decisions laid down in the EV Chinnaiah to a larger bench for the consideration in light of the Article 338 and the law laid down in the Indira Banerjee judgment after hearing the parties on the questions of the constitutional validity of the provision in question, the state's legislative power to enact such provisions, and on whether EV Chinnaiah needs to be revisited. The judgment in the matter was reserved on August 17.